this is the study of commercial law review from the book of Villanueva. So, the Code of Commerce, one of the topic under the commercial law. The Code of Commerce, the applicability of this code under Article 2070 of the Civil Code expressly repealed the provisions of the Code of Commerce on the following areas: the PAG-LSD, partnership, agency, guarantee, loan, sales, and deposit. So those are already repealed under the Civil Code. Next, the provisions of the Code of Commerce are still applicable as to the following commercial transactions: the Crambaktak JL, the charter, respondentia, averages, maritime, commerce, bottomry, bill of lading, joint accounts, aval, cross checks, transportation, arrival under stress, collision, joint accounts, and letters of credit. So these are still applicable. Now, preliminary articles of the Code of Commerce. The Article 1, for purposes of this code, the following are merchants. So who are those merchants? The very first is that those who having legal capacity to engage in commerce, habitually devoted or devote themselves thereto. So first, those who having legal capacity. So the natural person has the legal capacity. So therefore, they are able to engage in commerce. And number two, provisions on commercial or industrial associations have been repealed by corporation law. So also, merchants can be classified as merchants, those under in the commercial or industrial associations, as repealed by the commercial law. Next, Article 3, the legal presumption of habitually engaging in commerce. So what is Article 3? Talks about the legal presumption of habitually engaging in commerce shall exist from the moment, it should exist from the moment the person who intends to engage therein announces through circulars, newspapers, handbills, posters, exhibited to the public, or in any other manner whatsoever, an establishment which has for its object some commercial operation. So it means to say, the habitual engaging of commerce shall start or shall commence from the posting of announcement, circulars, newspapers, handbills, posters, an establishment, posting or announcing an establishment which has for its object some commercial operation. Next, Article 4, wherein persons who possess the following qualifications shall have the legal capacity to habitually engage in commerce. So, as a review, wherein in Article 1 of the Civil Code, those having the legal capacity shall have the qualification. Those having legal capacity can engage in commerce, the ability to engage. So in Article 4, these it is already being very particular already, wherein persons who possess the following qualifications shall have the legal capacity to habitually engage in commerce. So first is that a person to be in legal capacity, he must have attained the age of 21 years old. So again, to be a person to be in having the legal capacity is that with the age of 21 years old. And number two is that repealed by Article 117 of the Civil Code. We will just go back with what is that Article 117 of the Civil Code. And next is that having free disposition of their property. Next, Article 15, this is a bar with 5 star, wherein foreigners and companies created abroad may engage in commerce in the Philippines. Again, foreigners and companies created abroad may engage in commerce in the Philippines, subject to the laws of their country. Subject to the laws of their country with respect to their capacity of contract. So, capacity to contract, okay, shall be subject, their capacity to contract is subject to their foreign countries. So, foreigners and companies created abroad may engage in commerce in the Philippines, but subject to the laws of their country, their capacity to contract, and the provisions of this code of commerce, the provision of this code of commerce as regard the creation of their establishments in Philippine territory. So, if when it comes with capacity to contract, it is their law, the foreign law shall govern them, but it is our law or the code of commerce shall govern them in terms of creation of their establishments here in the Philippines or Philippine territory. Establishment of or creation of establishments here in Philippine territory, the mercantile operations, and the jurisdiction of courts of the Philippines. So they are already subject. Foreigners are subject to their foreign countries, foreign laws in terms of capacity to contract, but when it comes in terms of creation of establishments here in the Philippine territory and mercantile operations, they are already subject with the Code of Commerce of the Philippines. The provisions of these articles shall be understood to be without prejudice to what in particular cases may be established by treaties or agreements with other countries. The phrase habitually devote stresses the fundamental principle of habituality. As a result of the repeal of the Article 1, wherein the paragraph 2 is already repealed, it is already as a result of the repeal of Article 1 on commercial and industrial associations, only natural persons, only natural persons habitually devoting themselves to trade may be considered merchants. So only those natural persons governed by the code. So natural persons devoting themselves to trade may be considered merchants. However, the under Article 15 of this code already, under Article 15, diba, in Article 1, it is in Article 1 wherein natural persons may be considered as merchants, provided they have the legal capacity, attaining of 15 years old, having the predisposition where property. But in Article 15, wherein it talks about the foreigners or companies created abroad, so under Article 15, not only take note that not only aliens or not only alien individuals, but also, there is but also, it means to say but also foreign entities may engage in commerce in the Philippines to the extent that nationalization laws are not violated and subject to applicable laws, rules, and regulations. So that is in under Article 15, in which not only alien individuals but also the foreign entities, provided it is not a violation of the nationalization laws. In line with Article 1's definition of merchants, Article 3 provides a presumption of individuals being merchants when they announce through circulars, newspapers, handbills, public posters, or in any other manner an establishment which has for its object some commercial operation. But however, can still be rebutted, the Article 3, the presumption, by evidence to the contrary. Before the enactment of the family code, the civil code provided limitations on when husband or wife may deal with conjugal partnership under partnership property. Under the family code, common provisions apply equally to both spouses. Under Article 73 thereof, Article 73 of the family code, either spouse may exercise legitimate profession. So that is under the family code already, the Article 73, wherein it talks about either spouse may exercise any legitimate profession, occupation, business, or activity without the consent of the other. That's the general rule. That's the general rule wherein either spouse may exercise any legitimate profession, occupation, business without the consent of the other. And that other and latter may object only on valid, serious, and moral grounds. So that is the limitation. That is the limitation. Again, as a general rule, either spouse may contract to or may engage in profession, occupation, or business. So they may either without the consent of the other, but provided that other partner, the other spouse, may object on what ground? It should be valid, serious, and moral grounds. In case of disagreement, the courts shall decide whether the objection is proper. However, if benefits accrued to the family prior to the objection, the resulting obligation shall be enforced against the community property. Otherwise, the same shall be chargeable against the separate property of the spouse who has not obtained consent of the other spouse.